Well, I'd just firstly like to thank Tom and Scott and the IWRA for organising this fantastic webinar, and to my esteemed colleagues for inviting me to be a part of it, and also to all the listeners out there for participating. So I'm really just going to, I guess, the 4 sections of my presentation are up there, as you can see. So my presentation is essentially pulling together what the 4 previous presenters have spoken about and kind of looking forward now in terms of what are the practical steps that we can take for institutional coordination and coordinated implementation of these 2 what will essentially be global conventions, global water conventions in force as of August, when the UN Watercourses Convention comes into force in August. So I'll be very brief. I'm just going to basically run through those key 4 points in my presentation. So I just want to set the scene, some key points to consider. Then I'll run through just a brief sketch of the complementarity and differences regarding both conventions and how they're a package of norms together. And then I really want to focus then for the majority of the presentation, and I won't be long, but I just wanted to focus on 3 basic options for institutional coordination and taking a package approach for implementing the 2 global water conventions. And then lastly, leading into discussion with all of the participants in the webinar, I kind of wanted to throw it out to where do we go from here, not only with the UN Watercourses Convention, but the UNECE Water Convention, and how will they work together, and then looking more broadly at MEAs and other institutions, and then throwing it out to obviously the wider audience for their consideration. So I'll just start. So here's just a few things to consider. So this, just to start the conversation, the presentation that I'm giving is essentially an amalgamation of a discussion paper that you can find on the internet, which Alistair, Flavia and myself wrote in 2012, 2013, when we were hoping that the UN Watercourses Convention would enter into force, but it wasn't actually a concrete reality as it will become. So, and that essentially looked at when it does come into force, how we, what are the options for coordinating both of those conventions. So there's a discussion paper there, and this is also an amalgamation of that with an article by Alistair and myself recently published, which is around what are the complementarities between the 2 conventions, and that leads into then how are they coordinated in a complementary way. So this is an amalgamation of those 2 pieces of work, which are otherwise available. And so I just want to set the scene here with some basic things to consider. So obviously, as of August 2014, there will be 2 legal framework instruments covering transboundary water issues in force effectively at the global level, with the UNECE Water Convention open to ratification from states outside of the UNECE, and with the UNWC in force as well. So this development raises the question over the compatibility of both instruments, and really the fundamental question that I'm considering is how they might be implemented in a coordinated manner. And in that, we have to look at the similarities and differences between them, but essentially what we've found in terms of the research that I've been a part of is that they're essentially complementary, and I think that comes out in most of the speakers today, and also in a lot of the research out there. Sorry about that. There's a significant benefit also in promoting and implementing the conventions as a package when it comes to implementing them in a coordinated way. And in terms of that, there are 3 basic institutional options that can be envisaged in terms of the research that I've been involved with to support that package approach. And so this presentation will discuss that package approach to implementation of both conventions and how that offers the best means by which to strengthen the law of international watercourses more generally. So I'll just go briefly into comparing the texts of both conventions. So the scopes of both conventions are largely similar. A key distinction here concerns their respective treatment of groundwater. I won't go into the details there, but that's up there on the screen. In terms of the substantive norms and the similarities and differences, they do offer a similar package of substantive norms. However, they are presented differently between both instruments. The UN Watercourses Convention places all substantive provisions under the overarching requirement of equitable and reasonable utilisation. In contrast, the UNECE Water Convention does not put equitable and reasonable utilisation at its forefront, and generally takes the approach of the principle of do no harm, or no significant harm. So, however, whilst they're articulated slightly differently, both conventions essentially adopt the same package of substantive norms that encompass the key principles of equitable and reasonable utilisation, prevention of significant harm, and the protection of ecosystems, which Owen just spoke about. Comparing the text of both conventions again in terms of procedural norms, there is a distinction between the UN Watercourses Convention and the UNECE Water Convention concerning the treatment of existing and future legal institutional arrangements. In the UNWC, states are encouraged to harmonise such agreements with the provisions of the Convention, whereas the UNECE Water Convention obliges states, where necessary, to revise existing arrangements in order to eliminate contradictions, but that they also must enter into watercourse arrangements where they do not already exist. While these distinctions may appear significant on paper, in practice they may be mitigated by the UN Watercourses Convention's consistent emphasis on cooperation at its heart. And then lastly, in terms of comparing the text, the dispute avoidance provisions, the two conventions provide relatively similar provisions regarding the settlement of disputes, by which both states are encouraged to seek a solution to any dispute. Are encouraged to seek a solution to any dispute by negotiation or other means, such as good offices, mediation or conciliation. One of the key differences is that UN Watercourses Convention explicitly provides for a fact-finding commission to collect any information relevant to a dispute. So there's some of the major substantive procedural norms in terms of their similarities and differences between the two conventions, as well as scope and dispute avoidance. So what does that lead us into in terms of coordination of these two? So here are some key questions for institutional coordination and implementation. So how best do we build on the synergies and ensure coordination and avoid duplication in the implementation of both of these conventions? How can states capitalise on both the global legitimacy of the UN Watercourses Convention as well as the vast experience under the UNECE Water Convention to provide a truly global transboundary water regime? How might an institutional framework address existing water law fragmentation at different scales, which I think Salman touched on, as well as Flavia as well? And then what steps would we need to take to ensure that these conventions receive the political, technical and financial support necessary to facilitate effective implementation? So here on your screens is just a diagrammatic representation of, and I have to preface this with saying that whilst I will present three basic main institutional options, this is by no means the only options, and these are just three options that in the course of my research with Alistair and Flavia as part of a bigger piece of work under the UN Watercourses Convention Global Initiative, we essentially sought to map out the potential institutional framework for implementation, covering not only the two conventions, but broader institutions, broader MEAs. And so what we've done here is we essentially distilled it into three basic main institutional options for the coordination of these two conventions, upon which to base a global regime for transboundary waters. So in option 1, we have the UNWC institutional framework created and a UNECE Water Convention Secretariat mandated to also service the parties to the UNWC. So that's a combined. That's the combined option. In option 2, we have the parallel option, where we have 2 formal institutional structures, but operating in a coordinated manner. And then in option 3, we have the informal institutional framework or institutional arrangements that are currently in operation for the UN Watercourses Convention, which has no secretariat or the provisions within the convention to create such a secretariat, and the UNECE Water Convention operating as it does with a formal secretariat and formal bodies underneath the convention. So they're the 3 main options, but as I said, by no means at all the only options, and this is just some of the research that I've been a part of with some of my colleagues present today around trying to flesh out what the future institutional framework may look like for implementing these 2 conventions in a coordinated manner. So I'll just delve into them one by one briefly in terms of their strengths, basic opportunities, and some of the weaknesses and threats under each of them. So in the first one, which is, as we saw, was a combined option with a combined secretariat operating for both conventions. I won't go into detail, but I mean, this is available, as I said, online, and I'll provide the details after we're done. But you can see there, so the strengths of the combined option is it's likely to be the most effective means by which to ensure that both instruments develop in a complementary and mutually reinforcing manner. A shared secretariat would also offer the most effective and efficient means by which to develop a common strategy for promoting new membership to both conventions. This option would also create a clear entry point and one-stop shop, which I think Flavia touched on in terms of having that kind of focal point and beacon for championing transboundary water issues at a global level. And also it would require less resources and time compared to establishing a completely new secretariat and separate activities for the UN Watercourses Convention. Some of the weaknesses and threats of this combined option are that one that we thought might be possibly an issue is the fact that a secretariat based in Geneva may be perceived as being less favourable by some countries, given that the UN Watercourses Convention is a global convention, and there may be riparian nations who would prefer a new secretariat to be set up in somewhere else. But as I said, this is just kind of throwing ideas out there as to possible weaknesses and threats. This may or may not be one. And also, this option will require both a formal decision among the parties to the UNECE Water Convention to expand the mandate of their secretariat, and would also require an amendment to the UN Watercourses Convention incorporating provisions on governance mechanisms, and that could take considerable time and resources to secure. So option 2 was the parallel option, where you have both conventions with formal institutional arrangements, but operating in a coordinated manner. So the strengths of this basic option is that if it was hosted by an existing global organisation active in water issues, the UNWC could provide that organisation with a strong legal mandate to further its aims and objectives. It would also be an opportunity to create an entirely new governance mechanisms for the 21st century under the UNWC. As opposed to the option 1, it would not require any further changes to the UNECE Water Convention institutional framework as it currently exists. The UNWC Secretariat could be located in a developing country and or in a region where there is a strong need to enhance transboundary water arrangements. And this could give added impetus to strengthening transboundary water cooperation in that country or region as a possibility. There's also the fact that non-UNECE states could be more attracted to the UNWC with its institutional home being a global body rather than a structure associated with the UNECE as it currently stands, which was essentially set up as a regional convention, obviously with global aspirations. The weaknesses and threats of this parallel option with two formal arrangements operating side by side is that a formal secretariat and many of the parties would require all parties to agree on the adoption of an amendment, which could take time. If hosted under an existing organisation, this would require a decision by the governing body of that organisation in question, which again could take time and resources to secure that positive decision. And where the governing body of a potential host is made up of states, considerable effort would likely be required to build widespread or otherwise required unanimous support for that decision. Some other weaknesses and threats of this parallel option is that creating two parallel regimes would require high startup costs and running costs for two institutional frameworks. Separate secretariats would increase the effort, time and resources required to coordinate between both of those institutional frameworks under both conventions. It might be easier to demonstrate the benefits of two institutional frameworks serviced by a unified secretariat as envisaged in option 1, given that the UNECE Water Convention regime is already established. And similarly, a less formal arrangement as described in the next option might prove more feasible than in this parallel arrangement. And so we'll go into option 3. And so option 3 is essentially what is happening at the moment, where you have the UNECE Water Convention with a formal structure under the UNECE Water Convention, and you have the UN Watercourses Convention operating without any formal institutional structure or the provisions within the convention for those formal mechanisms, but at the same time garnering support through informal mechanisms and the championing of certain riparian states, and that is essentially what is happening at the moment. So the strengths of continuing in this kind of current situation would be that there would be the fact that there's no formal institutional framework established coincides with the current situation, which might be more acceptable to the parties that originally ratified the UN Watercourses Convention on the basis that there would be no need for financial commitments to support such a mechanism. The informal arrangements could be put in place to support the implementation on development of the UN Watercourses Convention in the absence of a formal institutional framework, so that it could continue as it currently is, which may be a more attractive option for parties. The cost of this option would be relatively low and non-structural, and this option would also accommodate proposals that have already materialised to host a meeting of the parties upon its entry into force. And some more strengths associated with this option are that an informal platform could evolve into a more sophisticated mechanism down the track, so this doesn't actually preclude a formal institutional arrangement evolving from the informal arrangements at present, as has happened with other MEAs. The UNWC would remain an authoritative statement of existing and emerging customary international law, and obviously now entry into force in force treaty as well. And the again, focusing on the fact that there could be an evolution of the arrangements from informal to formal, which would essentially move them into either option 1 or option 2 as the parties saw fit. Weaknesses and threats under this option 3 of the status quo is that the absence of an institutional home for the UN Watercourses Convention may be seen as a barrier to accelerating further ratifications in the future, in terms of having that champion to push that agenda. The lack of a mandated structure to oversee the UN Watercourses Convention may make it harder to mobilise donors and partners around implementation, and it also may be, and this is a crucial point, harder to coordinate activities between the UNECE Water Convention and the UN Watercourses Convention if there's no formal institutional framework for the latter instrument. So, some key points to consider for all the options as I wrap this up is to allow the UN Watercourse, so effective coordination would allow the UN Watercourse Convention parties to capitalise on 20 years of experience in the implementation of the UNECE Water Convention, which has a very storied and extensive history of highly technical experience in implementing the convention and also developing sub-bodies under the agreement for implementing the convention. Also, this would provide parties to the UNECE Water Convention with the opportunity to exchange experience with parties to the UN Watercourses Convention. It would also enable both conventions to operate at the global level whilst providing states with some flexibility. And what you're seeing here is that all three options essentially envisage either or both conventions operating at the truly global level, and what we're going to see in August is both conventions operating essentially at a global level. What I'll do is I'll just wrap this up with the final key points to consider for future coordination implementation. These are the 3 points that I'd kind of like to throw to the wider audience and to kind of get that conversation started, is that there are key similarities and differences between both conventions, but collectively, when taken together as a package of norms, both conventions are generally complementary in nature in the texts and provisions of both conventions. There are many ways in which both conventions may evolve in terms of formal or informal institutional frameworks, whether that be separately or together. But whilst there are many ways that could happen, there are several basic options which exist which may assist in the planning for their future coordination. And having said that, the final point being whichever method is considered for their separate or joint coordination, and whatever way the development of both conventions continues, the experience from other MEAs shows us that coordinating these 2 conventions will enhance their mutually effective implementation. And to seize on what Flavia said, and I think what all of my colleagues and many people out there will probably agree, is that this is a unique window opening now to seize the opportunity for planning this coordination. So I'd like to thank everybody for listening and pass it over to you, Scott.
Thank you very much for that presentation.